welcome to the 260th Legal Empowerment Through Interaction lecture series. It's a momentous occasion for us, and it is even more a beautiful day, a Saturday. Why? Because we have our own family member, Sri Virupaksha Gowda sir, who has taken a class earlier and was a regular participant on our platform on a very, very important topic. Not just for practicing lawyers, but for everybody who is concerned with any business activities or anything to do with something to be reduced into writing, into stamp, etc. It is impounding of unstamped and insufficiently stamped documents. We'll be dealing in depth on this topic, and without wasting any time, and at the same time welcoming you all to this 260th session. May I request Sri Virupaksha Gowda sir to address us on this very important and very, very beautiful topic, if I may say so. Over to you,
Thank you, sir. Thank you for inviting me to address this gathering on this occasion. I would like to refer to one judgment of Supreme Court in 2001, Chilamakuri Gangulappa versus RDO Madanapalli, where it is observed that when a document was found to be insufficiently stamped, further proceedings were unwittingly diverted through a wrong track. After it covered a long distance, everybody concerned realized that the list was proceeding through a wrong course. In this case, a document was impounded by the trial court, and the same was forwarded to the collector for collecting necessary stamp duty and penalty. The collector, who had to simply act on the consideration shown in the document, he called for a report about the real market value from his subordinates. And based on that real market value, whatever given by the subordinate officer, he proceeded to levy the stamp duty under section 47. And then the party had a grievance, and he went in appeal to a senior civil judge, and from there to High Court, and ultimately the matter reached the Supreme Court. Supreme Court said this was a case where, based on whatever consideration noted in the document, the necessary stamp duty, deficit stamp duty and penalty was to be collected. And on account of ignorance at all levels, the list had reached the Supreme Court, and there was much wastage of time. So I am always of the opinion that this aspect of law, this branch of law, is required to be known by one and all, by the advocates, judges, ministerial staff, everyone. As far as the
some connectivity issue. So you'll have to unmute.
Yes.
What happens, sir? Power failure.
Power failure, sir.
Okay, okay.
All of you must be aware. All of you must be aware that in the decision of Supreme Court in AIR 2001 Supreme Court, it is laid down that whenever any objection is raised, regarding any evidence at the evidence taking stage, the trial court should make note of such objection and proceed with the trial and decide the objection at the end. This is the judgment in Bipin Shantilal Pancha versus State of Gujarat. But ultimately, it is said that in respect of all objections relating to stamp duty, and registration, the objection should be decided then and there. The objection relating and registration cannot be postponed to a later date. And that is the judgment of Bipin Shantilal Panchal. The decision regarding any objection relating to stamp duty and penalty is required to be made by the judge himself, and it cannot be delegated to any other officer. In section 33, shall I switch back to this iPad 1 second?
Sure, sir. Sure, please. Please go ahead. Sir, you may have to switch off the other gadget to avoid echo. Yes.
Sir, in section 33 also, it is said that only in the case of a judge of High Court, he can delegate it to In the case of a judge of High Court, the duty of examining and impounding any instrument may be delegated to such officer as the court appoints in this behalf. In the case of any other judicial officer, the decision adjudication has to be made by the judicial officer himself. Now, sir, as far as the objections relating to admissibility of documents in the context of Stamp Act, I have identified three subtopics. That is impounding of insufficiently stamped documents, permissibility of using such documents before evidence collecting stage, and legal effect of such insufficiently stamped documents which are admitted in evidence by inadvertence. As far as impounding is concerned, the word impounding is not defined. The word impounding is not defined anywhere in this act. That word impound is equated with the power or duty to collect necessary stamp duty and penalty. Neither the ordinary dictionary meaning of the word impound nor the scheme of Stamp Act suggest a course of collecting the amount forthwith. In the normal court language, we often understand that when a document is ordered to be impounded, we assume that we are required to pay the amount forthwith. But that is not so. The ordinary dictionary meaning, Oxford Dictionary defines the term impound as take possession of by law or authority. In one of the judgments of Kerala High Court, in 2005 4 KLT 273, PK Mohanan versus Muvattu Puja, the expression impound means taking possession of the document in custody as per law. So impounding does not mean collection of amount forthwith. The collection of the deficit stamp duty and penalty would come at a later day, at a later stage. The sections 35 and 38 stipulate the procedure to deal with such impounded documents. They suggest that collection of stamp duty and penalty need not be the only mode of dealing with the impounded documents. As per section 35, the presiding officer may admit the instrument in evidence upon payment of requisite duty and penalty, which is equal to 10 times the duty. In other words, the party has an option to pay the requisite stamp duty and penalty in the court itself and urge that the document may be admitted in evidence, in which event he has to pay the mandatory 10 times penalty. However, the party also has an option to request the court to forward the impounded instrument to the collector to levy and collect necessary stamp duty and penalty. Generally, a party makes use of this option since the collector is not under a statutory obligation to impose 10 times penalty. The collector can impose a penalty of ₹5 only under section 40 of the Stamp Act. In a judgment of Andhra High Court reported in AR 1975, AP page 96, it is stated that when the party makes an application to send the document to collector, the court is bound to accede to the request. In case the party does not pay the duty and penalty in the court, and he also does not apply to send it to the collector, the presiding officer is bound to send the instrument to collector as laid down in section 38 of the Stamp Act. It is for the collector to take further action in the matter. The court, in respect of the impounded documents, the court cannot return such document to the party. Order 13 Rule 8 lays down that such impounded documents shall not be returned to the party. This fact explains the scope of impounding. The entire scheme of the Stamp Act and the dictionary meaning of the term impounding would therefore make it explicitly clear that an insufficiently stamped document shall be retained in the custody of the court till the party makes use of it by paying necessary stamp duty and penalty, or till he applies to the court to send the same to the collector. It is only as a last resort. It is only as a last resort that the presiding officer is required to send it to the collector suo motu under section 38(2) of the Stamp Act. Section 33 of the Stamp Act exempts certain documents from the operation of section 33. The documents produced before a criminal court, especially documents produced in connection with matters pertaining to section 125 CRPC and section 145 CRPC, the criminal court need not impound those documents, and those documents can be looked into even if they are deficitly stamped. Probably the reason is I'm sorry, the other way around. In all cases, except, I'll just read section 33. In all cases, in all criminal cases, except the cases pertaining to section 125 CRPC and section 145 CRPC, the insufficiently stamped documents can be looked into. But in cases pertaining to 125 CRPC and in cases pertaining to 145 CRPC, where there may be any family arrangements or any documents pertaining to immovable property, the documents cannot be looked into, and then they have to be necessarily impounded. Probably the legislature will have to consider whether the offences under section 138 NI Act also need to be included in this proviso A of section 33, because in connection with offences under 138 NI Act also, several such insufficiently stamped documents are pressed into service. Now, as per as the failure of the parties to raise objection when any insufficiently stamped document is produced as an evidence, the section 36 says that the party cannot raise that objection if he had not raised the objection at the time of marking the document or at the time of admitting the evidence, admitting the document in evidence. Now, section 36, I will read section 36. When an instrument has been in evidence, has been admitted in evidence, such admission shall not, except as provided in the section 61, be called in question at any stage of the same suit or proceeding on the ground that the instrument has not been duly stamped. Now, this section 36 only says that whenever any document is admitted in evidence, such admission, the question relating to admission of a document, cannot be called in question at any stage of the same suit. But as per section 35 of Stamp Act, there are two prohibitions. The first limb of section 35 says, no instrument chargeable with duty shall be admitted in evidence for any purpose by any person having by law or consent of parties authority to receive the evidence. The second limb of section 35 says, no such instrument shall be acted upon, registered or authenticated by any such person or by yes, sir. No instrument chargeable with duty shall be admitted in evidence for any purpose by any person. This is the first limb of section 35. The second limb is or shall be acted upon, registered, authenticated by any such person or by any public officer unless such instrument is duly stamped. Now, sir, please refer to section 36. Where an instrument has been admitted in evidence, such expression shall not, except as provided in section 61, be called in question at any stage of the same suit or proceeding on the ground that the instrument has not been duly stamped. A reading of section 36 would say that an objection that such an insufficiently stamped document shall not be acted upon, registered or authenticated would continue to operate in spite of section 36 of Stamp Act. So now my understanding of this section 35 and 36 is that a party may be prohibited from, a party may be disabled from challenging the question of admissibility, but yet the question whether it should be acted upon or not still survives, and that objection can always be taken by the court or the public officer. Now I have one judgment. In AR 1969 Supreme Court, page 1238. So, para 4, an instrument which is not duly stamped cannot be received in evidence by any person who has authority to receive evidence, and it cannot be acted upon by that person or by any public office. Section 35 provides that the admissibility of an instrument once admitted in evidence shall not, except as provided in section 61, be called in question at any stage of the same suit or proceeding on the ground that the instrument has not been duly stamped. Relying upon the difference in the phraseology between section 35 and 36, it was urged that an instrument which is not duly stamped may be admitted in evidence on payment of duty and penalty, but it cannot be acted upon, because section 35 operates as a bar to the admission in evidence of the instrument not duly stamped, as well as to its being acted upon, and the legislature has by section 36 in the conditions set out therein removed the bar only against admission in evidence of the instrument. The argument ignores the true import of section 36. By that section, an instrument once admitted in evidence shall not be called in question at any stage of the same suit or proceeding on the ground that it has not been duly stamped. Section 36 does not prohibit a challenge against the instrument that it shall not be acted upon because it is not duly stamped, but on that account there is no bar against an instrument not duly stamped being acted upon after payment of the stamp duty and penalty according to the procedure prescribed by the Act. The doubt, if any, is removed by the terms of section 42(2), which enact in terms unmistakable that every instrument endorsed by the collector under section 42 shall be admissible in evidence and may be acted upon as if it had been duly stamped. Now, sir, there was a controversy whether in view of the judgment of the Supreme Court that section 36 does not enable any objection regarding admissibility, and this judgment of 1969 is in conflict with the other judgment. Then the judgment in one judgment of AP High Court, AAR 1982 Andhra Pradesh, page 240. Para 19, there is yet another aspect on which there was a debate, and therefore it must be adjudicated. The question is whether, even if the document is said to be admitted in evidence, could it nevertheless be acted upon within the meaning of the interaction of the provisions enacted in 35 and 36 of Stamp Act. In other words, though the document might have been admitted in evidence, and once it is so done, the embargo contemplated by 36 bars only the objection being raised that the document which is not stamped should not be admitted in evidence. But still, the question remains whether such a document admitted in evidence can be given effect to within the meaning of the second limb of section 35. That is, whether the document should be acted upon. Adverting to this situation, the Supreme Court in AR 1969 held, I have read that 69 judgment, Sri Ranganatham Learned Counsel for the petitioner submits that there is some equivocality in this decision, and since it is rendered by a bench of 3 judges, it may not be followed in view of the decision in Javer Chand, which though earlier in point of time is by a bench of 4 judges. No doubt, it is true that in case of a conflict between 2 decisions of the Supreme Court, the one decided by a larger bench, even if it is earlier in point of time, will have to be followed. But I do not find any conflict between the 2 decisions, and therefore the proposition is unfounded. The 1961 decision pertains to the question whether any objection could be raised when once the document has been admitted in evidence that it is not stamped within the meaning of 36 of the Stamp Act, and court held that no such objection could be entertained. Whereas in the 1969 decision, the question was whether in an insufficiently stamped document, though admitted in evidence, can yet be acted upon or not. In view of the above, since there is no conflict between the 2 decisions, the question as to which decision has to be followed does not arise. So following the decision of the Supreme Court, I hold that even assuming without laying down that Exhibit B2 has been admitted in this case, the question whether it should be acted upon or not is still res integra, and therefore it is open to the court to decide whether it should be acted upon and given effect. To hold otherwise would be rendering the provisions contained in section 42(2) of the Stamp Act OTOs, as it enacts that every instrument endorsed by the collector shall be admissible in evidence and may be acted upon as if it has been duly stamped. So, sir, in view of these 2 judgments, I am of opinion that in spite of section 36 of the Stamp Act, 36 of the Stamp Act, which says that such objection relating to admissibility cannot be pressed any longer, they question whether the insufficiently stamped document can be acted upon, authenticated, registered, still survives for consideration. Now, many of the judgments have laid down that the objection relating to the insufficiency of stamp duty can only be taken by the court, and a party can be called upon to pay penalty only when the document is sought to be adduced in evidence, that is at the stage of trial. Now, if that stand is taken, whether by taking up the taking the plaint on file, whether by registering a suit on the basis of such insufficiently stamped document, would it not amount to say that the public officer or the court has acted upon a document which is insufficiently stamped and which is in violation of the second limb of section 35 of Stamp Act? Secondly, whether such in some of the judgments it has been said that the objection regarding stamp duty shall not be raised at the time of registering the suit. But in view of the second limb of section 35, it is doubtful whether such a stand can be taken. Secondly, whether such insufficiently stamped documents can be admitted in evidence at the interlocutory stage, whether the objection relating to insufficiently stamped documents can be raised at the stage of considering of interlocutory applications also. Now, the difference between Stamp Act and Registration Act is very well known. The Registration Act makes some exceptions that an unregistered document can be looked into for collateral purpose, whereas in the case of a Stamp Act, it shall not be used for any purpose. That is the command of the legislature as far as insufficiently stamped document is concerned. So there was a case where a party wanted to make use of this insufficiently stamped documents while considering interlocutory application. Both the Karnataka High Court and Andhra Pradesh High Court have held that in AR 2003 Karnataka 241, so long as that instrument remains unstamped, section 35 forbids its user for any purpose whatsoever by the court, authority, or person. The expression for any purpose appearing in the section is wide enough to include within its amplitude use of the document for the purposes of issue or refusal of injunctions or similar other reliefs. There is nothing in the scheme of Stamp Act to show that a document which is either unstamped or understamped can be made use of for purposes of issue of injunction or for grant of any other interlocutory order. Similarly, in one case, a party wanted to make use of such insufficiently stamped document to confront the witness with the signature found on the document or for the purpose of comparison of the signature. The High Court of Andhra Pradesh in AIR 1972, Andhra Pradesh 373 said, no part of a document, be it a single sentence, word, or a signature, which is chargeable with duty, can be received in evidence, and to do so is to do violence to section 35 of Stamp Act. Now it is well known that there is another judgment of AP High Court in 2010, 5 Andhra legal decisions, that objection can be raised even in interlocutory proceedings. Now, sir, it is well known proposition that whenever we consider the document for the purpose of stamp duty or for the purpose of ascertaining whether it is required to be registered, it is not the nomenclature which decides. The contents of the documents have to be looked into. Now, since there was large scale evasion of stamp duty. Almost all the states have amended the provisions of the Stamp Act. Earlier, the unregistered sale deeds were rampant, and even in agreement of sale, a recital of delivery of possession was being made, and therefore, to avoid evasion of stamp duty, the legislature have amended the Stamp Act, saying that any document which contains a recital of delivery of possession should be stamped as a conveyance and not as a mere agreement of sale. Now, to get over this amended provision, some innovative methods saying initially an agreement of sale will be drafted without recording delivery of possession, and later in another document or on the reverse of the original document, a recital of delivery of possession having taken place on a subsequent date is recorded so as to nullify the effect of amendment. But the courts have taken a consistent view that evidencing are followed by delivery of possession. So even if the delivery of possession follows the agreement of sale, even then it is to be treated as a conveyance. Now another innovation is there is a recital of delivery of possession, but the party says, sir, that recital is incorrect. In fact, there was no delivery of possession. The person who is relying on the document might also say that to avoid the stamp duty and penalty, that though there was a recital of delivery of possession, the delivery of possession was not there. So it may not be considered as a conveyance. Or at times, the opposite party may take a plea that though there was a recital of delivery of possession, in fact, possession was not delivered in fact. But the Supreme Court has said that Supreme Court, though the defendant dispute that, but for determination of the question of admissibility of a document, it is the recital therein which shall be decisive, whether the possession was in fact given or not in terms of the agreement to sell is a question of fact which requires adjudication. But at the time of considering the question of admissibility of a document, it is the recital therein which shall govern the issue. It does not mean that the recital in the document shall be conclusive, but for the purpose of admissibility, it is the terms and conditions incorporated therein which shall hold the field. This is laid down in judgment of Supreme Court in Om Prakash versus Lakshmi Narayan, 2014, 1 SCC 618. Now, sir, though section 33 says that a judge of High Court can delegate his authority to another officer. Force 33(4). Subsection 4. Judge. Also. I think this is the old. Proviso B, sir. Samson. In one case, the judge not only the judge of a High Court entrusted the matter of adjudication of the nature of the document as well as the stamp duty payable to a registrar in Black Pearl Hotels Private Limited versus Planet M Retail Limited, AR 2017, Supreme Court 1974. It is said that it is quite plain that it empowers the judge of the High Court to delegate the duty of examination and impounding the instrument to such officer as the court appoints in that behalf. The question arises where the nature of document is disputed. The same can be done by the delegated authority. For example, if a document tendered is a sale deed and dispute arises with regard to its character, namely sale deed or deed of mortgage, can it be done by the officer concerned? The stamp duty payable on a lease deed or a license may be different. The delegation by a judge of the High Court will not clothe the officer the jurisdiction of determining the nature and character of the instrument, inasmuch as such facts needs to be determined by the judge while exercising judicial function. Such a judicial function is not to be delegated to an officer of the court by the judge of the High Court. What is delegated under the proviso B of subsection 2 of section 33 is only to examine the instrument for the purpose of determining as to whether the instrument is duly stamped or not, and for impounding the same. We are disposed to think that section 33 2B does not contemplate or permit any adjudication as regards the nature and character of the instrument. The delegated power has to be restricted to cover the area, that is whether the instrument bears the proper stamp and thus complies with the requirement of being duly stamped, and the stamp duty payable on the same must be determined only with reference to the terms of the document. Proviso B to section 33(2) does not empower the judge of the High Court to direct the officer of the High Court to inquire and to find out the nature and character of the document. It is evincible from the impugned order that the learned judge has left both the aspects, that is, determination of the nature and character of the document and impounding of the same to the registrar. The sentinel question that arises for consideration is whether the learned single judge, for the purpose of determining the character, could have delegated the authority to the registrar. A judicial functioning has to be done in a judicial manner. So that is the, though the judge of High Court is given the power to delegate the authority, the judge alone has to decide the nature of the document. As far as the judicial officers of the other courts are concerned, they are bound to do it on their own, and they cannot delegate it to the ministerial officers. The procedure to be adopted in the case of impounded documents is very, very well dealt with in a judgment of the Kerala High Court. P.K. Mohanan versus the Motor Accident Claims Tribunal, 2005 Kerala KLT 4 KLT 273. The expression impound only means taking possession of the document for being held in custody in accordance with law. Subsection 2 of section 33 provides that for the said purpose, every such person shall examine every instrument. In this case, in this judgment, two earlier judgments of the Kerala High Court in 1989, 1 KLJ 16 and 1997, 2 KLT 475 have been considered. Both these judgments have been held to be erroneous. I am afraid the legal position is not correctly applied in the above two cases. The whole purpose of the provisions under Chapter 4, as already referred to above, is to check the evasion of stamp duty. The petitioner produced certain documents before the tribunal. True, the same was not marked and not tendered in evidence, but the document forms part of the documents produced in court. On such production, the tribunal notices the insufficiency of stamp. The Act has conferred power on the authority to examine the documents produced before it or brought to its notice in the performance of its official duties and see whether those documents are properly stamped. No restriction whatever is discernible under section 33 that only those documents which are proved in evidence or relied on by the parties alone can be impounded. In the earlier two decisions, it was held that only if the party wants to rely on the documents as evidence on his behalf, the court can impound. But in this case, it is held that whenever any such document is produced before the court or public authority, the document will have to be necessarily impounded. The position as explained above, in fact, is not res integra. A division bench of this court in 1995 2 KLT 292 dealing with the court's power to impound a document, even when the parties are not before the court, held that whenever the infraction is detected, primary liability of the executant of the cannot be shelved for the reason that he never produced it before the court. Court's power to impound an instrument cannot be denied on the ground that the parties are not before the court. The next question is regarding the procedure. Section 34 makes it clear that only when an insufficiently stamped document is sought to be admitted in evidence, the court is empowered to impose penalty for payment of a sum equal to 10 times such duty in addition to the deficient portion of the stamp. The court, while impounding an instrument, shall send the original as provided under 37(2). In other words, the documents impounded by the court on mere production of the same, and when they are not relied on by the parties as part of evidence, have to be forwarded to the district collector for action under 39. Only when an insufficiently stamped document is sought to be admitted in evidence, the court is empowered to release the deficient portion and impose the penalty at 10 times. The difference between 34 and 39 in the matter of penalty is that a discretion is given to the collector under 39, but not to the court under section 34. In other words, if an insufficiently stamped instrument is to be admitted in evidence, it is permissible only if the deficiency is made up and 10 times the deficiency is paid as a penalty. As far as the document that is mainly produced before the court, the collector has a discretion to realize the deficit portion together with a penalty of 5, or if he thinks fit, an amount not exceeding 10 times the amount of the proper duty. The question whether the municip should not, by which every person is to send it within the description of every other case, means among cases mentioned, there is a case of a person impounding an instrument who has by law authority to receive evidence and admits such instrument in evidence. It is only when the case is different from the one mentioned therein that an occasion will arise for a civil court. Ordinarily, the duty or power of assessing the court is invested by the act in the collector. The proviso 34 invests courts with the special jurisdiction of adjudicating upon stamp duty and imposing penalty in certain cases. That is, where a party to litigation before the court tenders a document in evidence. In the instant case, as the documents have not been admitted evidence, no question of imposition arises. He could have acted only under 37(2), by which he is to send the documents to the collector, who then can proceed to stamp the instrument concerned and collect the required duty and penalty. In the instant case, the document is only produced before the tribunal. The same is not tendered in evidence. The tribunal is right in impounding the same, but wrong in realizing the deficient portion and imposing the penalty. Since the document was not adduced in evidence, the tribunal could not have called for payment of the stamp duty and penalty, and it could have only sent the document to the collector. Now, what is the stage at which the document can be sent to the collector? When the document is produced before the court and it is not sought to be adduced in evidence, so the court does not have the jurisdiction to collect the amount of stamp duty and penalty. He does not also make an application to send it to the collector for validation. So the document would be lying with the court custody. And as per Order 13, Rule 8, an impounded document cannot be returned to the party. What is to be done to that document? Is it to be said that the court has to wait till the disposal of the suit, and after the disposal of the suit to take some steps regarding the document? That cannot be so, because the court by delivering the judgment, the court will become functus officio, and therefore nothing more can be done after the disposal of the case. So in all such cases, probably the best course would be to keep the document in the custody of the court till the evidence is concluded, and before the case is disposed of, the document shall be sent to the collector for taking necessary action for collection of stamp duty and penalty from the concerned. Sir, whether the collector is bound to as stated in the section itself, the collector has a discretion to impose penalty up to 10 times. Now, Supreme Court has time and again said that that is only the farthest limit imposed by the statute, and the collector is not required to impose 10 times penalty in every case. And that financial conditions of the party and other things have to be taken note of. In one case, the trial court instead of imposing 10 times penalty, imposed only 2 times penalty, double the penalty, and validated the document. The matter was taken to the High Court, and High Court said the court has no discretion in imposing the penalty. It has to be necessarily 10 times the penalty. And the High Court set aside the order of the trial court, and the matter was taken to the Supreme Court, and the Supreme Court said High Court is right, but let the matter lie there, and let this double the amount collected be over. Probably the man has achieved a lot by going to the Supreme Court. That judgment would suggest that probably it cannot be taken as a precedent, because it is laid down that the order of the High Court is correct, but in the facts and circumstances of that case, that is the judgment in latest judgment in 2020. To 2029 SCC 510. 2019 3 SCC 788. Even in the earlier decision, it is held that collector has to take into account the financial position of the party. 2002 10 SCC 427. Sir, the second question is very often the original is not produced before the court, and a photocopy of the document is produced with a request that the same may be treated as secondary evidence by collecting necessary stamp duty and penalty. Now it has been laid down repeatedly by the Supreme Court and other high courts that a photocopy cannot be validated, and law does not provide for the levy of any penalty on lost documents. The question was whether the court can impound the photocopy of the instrument. The instrument means it is only the original instrument. Section 35 does not apply when the original document has not been produced and secondary evidence of its contents cannot be given. This is laid down in AIR 2007 Supreme Court 6368 Harimom Agarwal versus Prakash Chand Malviya. It is also stated in another decision of AIR 1971 Supreme Court 1070 Jupudi Kesavarao versus Pulavarthi Venkat Subbarao. In this case also, their lordships have made a nice distinction between the first limb and second limb. The first limb of section 35 clearly shuts out from evidence any instrument chargeable with duty unless it is duly stamped. The second limb of it, which relates to acting upon the instrument, will obviously shut out any secondary evidence of such instrument. Sometimes the practice of postponing the decision on objection has been condemned by the Supreme Court. It is said that whenever an objection is raised, the objection is to be decided then and there. This is laid down in Ram Ratan versus Bajrang Lal, AR 1978 Supreme Court 1393. When the document was tendered in evidence by the plaintiff while in the witness box, objection having been raised that it was inadmissible, it was obligatory upon the learned trial judge to apply his mind to the objection and decide the objection in accordance with law. Tendency sometimes is to postpone the decision to avoid interruption in the process of recording evidence. and therefore a very convenient device is resorted to of marking the document in evidence subject to objection. This practice is not approved, but when such an endorsement is made that the document is marked subject to objection, Section 36 will not come into operation, and at the time of final decision, the party may urge whatever grounds there are to object to the marking of the document. Now there is one judgment, sir, in Pondar Singh versus Nihal Singh, AR 2003 Supreme Court 1905, where certain observations give an impression that even an unstamped document can be looked into for the purpose of an unstamped and unregistered document can be looked into for the purpose of deciding possession. The observations I will read out. The main question, as we have already noted, is the question of continuous possession of the plaintiffs. The sale deed dated by father of the defendants is an admitted document in the sense its execution is not in dispute. The only defense set up against the said document is that it is unstamped and unregistered, and therefore it cannot convey title to the land. Under the law, a sale deed is required to be properly stamped and registered before it can convey title to the vendee. However, legal position is clear law that a document like the sale deed in the present case, even though not admissible in evidence, can be looked into for collateral purposes. In the present case, the collateral purpose to be seen is the nature of possession of the plaintiffs over the suit land. So based on that judgment, sometimes it is urged that even if it is an unstamped document, the question of possession can be decided. But this judgment has been distinguished in another judgment, AIR 2009, Supreme Court 1489, in Avinash Kumar Chauhan versus Vijay Krishna Mishra, where it is stated that the court in Bandar Singh was not concerned with the provisions of the Stamp Act. Only interpretation of the provisions of the Registration Act was in question. In SMS T Estates 2011, 14 SEC 66, there was an unregistered lease deed, and that lease deed contained a term regarding reference to arbitration. There, the question was whether that clause relating to arbitration could be looked into, even though it is not duly stamped. The Supreme Court held that because it was not stamped, that arbitration agreement clause relating to arbitration agreement also cannot be looked into. And this is all, sir, for I wanted to make a distinction between first limb and second limb of Section 35. The question whether it can be acted upon, I wanted to emphasize that objection would still survive. I wanted to make it a point that the party has an option either to pay 10 times penalty or to apply to the court to forward the document to the collector for adjudication, because in that event, he need not pay 10 times penalty. Then the objection regarding insufficiency of stamp duty can be raised even in interlocutory proceedings. It cannot be said that such an objection can be raised only during trial, and then recitals in the document to be taken for assessing the stamp duty and penalty. I don't know whether I have covered the entire gamut of the insufficiently stamped documents, but I think I have not missed out any important case.
Absolutely not, sir. In fact, doubts are coming up, and a couple of doubts also. There are postings. If I may just read one among the doubts, that is by Preeti and Matoli sir. Can a Xerox copy be impounded when it is sought to be produced as secondary evidence? The same is insufficiently stamped. You already answered that, but still.
There are two decisions which say that it cannot be impounded. Only instrument means only the original document and not Xerox copies. This is AR 2007 Supreme Court 6368 and AR 1971 Supreme Court 1070.
In the year 2007, I think you referred to Hariom Agarwal.
Hariom Agarwal.
Hariom Agarwal is AR, I think it is 2008 Supreme Court, 166. I'm not sure. There's a page.
Hariom Agarwal versus Prakash Chandra Malviya.
Yeah, Prakash Chandra Malviya, correct. But it's a 3-judge based decision. This is Navulkar.
Did I mention the citation correctly?
I think because you were referring to page number 6000 something.
6368.
Because I think it is AR 2008 Supreme Court 166. I have to see that. Even though it's a 2007 judgment.
Okay.
I think so.
Where?
There is another query put. There is a case where in Karnataka, a party has a promissory note on demand with signatures on revenue stamps. Revenue stamps were abolished in the year 2003-2004 in the state, and this is much later. Can a suit for recovery be filed relying on this document? Not exactly on the topic, but still. Also, in case it is preliminarily objected to by the other side, can we say we will prove along with the main trial? Can using a document with revenue stamps after it is abolished be relied upon to prove a transaction? Can this be a document be impounded or the case itself liable to be dismissed? Thank you very much by Preeti.
Oh, the Stamp Act requires that the value of the stamp as well as the description, whether it is a revenue stamp or a non-judicial stamp, it must comply with both the description and the value. So if the revenue stamps is abolished, it cannot be a proper stamp duty. And there is no provision for impounding and collection of stamp penalty in the case of promissory notes.
Correct. That's it.
Correct. We have Prashant Rayaroth with a question. Prashant, can you unmute and put the question? So the question is, an insufficiently stamped document unconnected with the suit was produced along with the suit by mistake. Prashant, please go ahead. Prashant is here. You are not audible, please. There is some connectivity issue. I think I'll read the question. An insufficiently stamped document unconnected with the suit was produced along with the suit by mistake. Later, it was sought to be returned during the pendency of the suit. Can the document mentioned above be impounded by the presiding officer?
It need not be connected to the suit. Whenever it comes to the notice of the court, whenever it is produced, probably it will have to be impounded.
So even if it is not connected with the suit also, it can be impounded.
It can be. Yes.
Yes, sir.
So Dilip sir, yeah, please.
Shyam sir, I couldn't follow the entire thing because there were some disturbance, and I couldn't just listen to it in parts and parts.
Okay.
So I'm not able to. But I think a document only when it is produced or when it is relied upon to be admitted in evidence that it could be impounded. By mere production, it need not be impounded.
True, true.
That contention has been overruled by Kerala High Court. Impounding is only to take possession, seize the document.
Yes.
We are not to collect the penalty.
No. I said that document is taken custody of. Custody of. Suppose only if it is produced and it is in the not in the file. I mean, it's only a part of file, but not a part of record. Can it be impounded?
It is to be impounded. It shall not be returned to the party. It is to be forwarded to the collector. An unstamped document cannot be given back to the party because there is breach of the provisions of the Stamp Act.
Sir, I think Ramesh Nathas Reddy sir has got a question. Please go ahead. Ramesh.
Okay, sir. Thank you, sir. Sir, my question is whether insufficiently stamped and unregistered mortgage deed can be received for collateral purpose of proving debt, not for mortgage.
You are complaining of two evils.
Yes.
One pertaining to the stamp duty and another pertaining to the registration.
Yes, sir.
Registration is a curable, incurable defect. Stamp duty is a curable defect.
For
If you want to
collateral
get-
purpose of proving debt, sir.
Even for collateral purpose, stamp duty and penalty has to be paid. Once stamp duty and penalty is paid, even an unregistered document can be pressed into service to prove the giving and loan transaction. But without payment of stamp duty and penalty, it cannot be pressed.
Thank you, sir.
In one of the judgments, it is said that it is not incurably defective. It can be cured. This can be said with reference to the Stamp Act. It cannot be incurably defective. It is not incurably defective. You can always pay the penalty.
May I add to one participant had asked a question regarding a suit for recovery of money on a document with the revenue stamp which is not in vogue. I think she can succeed the suit by proving the original transaction.
Original consideration.
Original consideration, she can, the suit need not be got dismissed as such.
No, he can fall back on the original consideration. That's
Original.
Original consideration. And that paper is a proof of original transaction. So not
That-
as a promissory note.
You cannot make use of the document.
As a promissory note.
to the extent of proving the original consideration.
Yes.
You can fall back,
Yes, yes.
but not on the document.
KJ Rao, sir, your comments.
Very well presented, sir. I mean, even for a layman like me, I mean, we understand the nuances of the question of registering a document, paying the stamp duty, and using it in evidence. It's actually good because today, at least now, most of the issues come up with builders where they don't, as you said, the recital of the document. The recital today by every builder has a different recital in his agreements, and that creates a problem. So they somehow want to subvert whatever the court's observations are. So, I mean, excellently explained. I mean, even with RERAs insisting, and that is why now I think even the Supreme Court has said that there will be a single format for sale and purchase agreements of flats. This could be one of the reasons, because too many cases in court and multiple interpretations which can be avoided. So excellent articulation, and thank you for being on the show. And thank you very much, sir.
So thank you, Rao, sir. Further questions are not there in the chat box. I think then we can go for the concluding remarks by Prem.
Well, that is an excellent articulation. And so I just would say one thing. I just refer to that Hariom Agarwal. It is 2008 Supreme Court 166. Corresponding to 2007 8 SCC 514. Hariom Agarwal versus Prakashan Malavya. I just refer to the book. Now, sir, I will have a small question for you. See, last judgment you referred to, for the judgment by a full judgment in SMS TFTs. 2011 66. Now, that particular judgment, the Supreme Court goes on to hold that an arbitration agreement in an unstamped document that is not enforceable in law because that arbitration agreement itself would be invalid. Subsequent to this particular judgment, there is another judgment by the Supreme Court, another two judges, 2019. But now see how the Supreme Court is going to flip flop. These are two judge bench decisions. The next decision is a one in our court Narayan Swamy Mudaliar's case, 3 judgments, 2024 SEC 612, where the Supreme Court upholds SMST. Then comes the next 3 judge, Vidya Drolia's case, 2000 Vidya Drolia, 2021 2 SEC page 1. Where again the Supreme Court goes on to hold that what was held in Garware Waldrops, because Garware Waldrops also went on to say, hold that the arbitration clause that itself would be non-existent in law and unenforceable until you pay the whole stamp duty, because it's a substantive commercial agreement. Now see what happens. The latest judgment comes in another 3 judges. NN Global Mercantile, 2000 NN Global Mercantile, 2021 volume 4 SEC 379, where another 3 judge bench goes on to hold that the arbitration agreement, even if it is contained in an unstamped agreement, it is valid, it is existent, it is enforceable in law. Now here,
standalone agreement.
Standalone, because here the bench goes on to say the doctrine of separability of that arbitration agreement, and of course the doctrine of compens. Now the entire confusion is regarding, of course, NN Global goes on to overrule 2011 SMST, of course, but that 3 judge bench decision is not conducive to clarity because it lacks the judicial competence to sideline the 3 judge bench decisions in Vidya Drolia as well as our court Narayan Swamy Mudaliar. Our court Narayan Swamy Mudaliar was not even referred to in this judgment. On the other hand, it makes mention of Vidya Drolia, judgment at para 92 of Vidya Drolia, it approves Garware Wardens. And para 92, that was doubted and that has been sent for reference to answer to a constitutional bench. But the view taken in our court Narayan Swamy Mudaliar, that was not even referred to. So, does that particular doctrine of separability or that standalone, and that salvage an arbitration agreement in an unstamped agreement? What is your take on this issue?
I would still say that no part of the unstamped document is admissible unless you pay the stamp duty and penalty. Because when we don't even permit the signature to be made use of, signature, we need to have some consistency.
Sir, the definition of arbitration agreement going by the act is that it can be even a clause, etc., etc. So will that not make
Section 11(6)?
Yes. So it can be, even though it is embedded in something else, which might be deficient, but this will float even if the everything else sinks. I think that might be the logic behind the.
But the dispute to be arbitrated is contained in the document.
Well, that is, of course, then arbitration clause will survive. The consequences, etc., let us see later. But that is 2 different things.
But at the initial incept, what the court has to look into is whether there is a valid arbitration agreement.
Yes. And arbitration agreement going by the definition could be even a clause in another agreement.
The same thing is going to happen in case of section 7 of the IBC also.
Yes.
Same issue to happen.
But Shyam sir, won't that be a bar because the document itself is not stamped? The arbitration clause in that document, will it survive?
It cannot be said that it is in the agreement. My reasoning is that even if it is in whatever form, even by exchange of letters, whatever, I mean, if you see the definition of arbitration agreement going by the Arbitration Conciliation Act, even though it might be placed in a different context or different thing, but that will stand. Like Dilip sir asked, then what will happen? That's another story. Whether he'll succeed, etc. But as far as the query is concerned, I think that clause cannot be tied down to the registration or stamp of the other things.
That is
Full
based on
document.
section 11.6. Section 11.6 that contains this particular doctrine of separability, of course. But can that alone salvage is a question? Why? Because you have 2-3 judges in opposition. One of
That is
opposition is referred to a larger bench. The other 3 judges has not been even referred to. It has not been even referred to, because then that what happens to that judgment? Unless the reference is answered by the constitution, of course, then things would be different. And now the main problem is that the lower courts get confused.
Yes.
Now you have 2-3 judges against the latest 3 judges. Which one you are going to follow?
Going by the decision.
I mean, we can debate over that, but what about the judicial officers in the lowest level of the judiciary?
Prem, I got a further doubt. Just see section 7.2 Arbitration Act. An arbitration agreement may be in the form of an arbitration clause in a contract. Contract is an agreement enforceable under law.
Yeah.
So if it is informed in any other manner, then how do you cull it out? It has to be in a contract which presupposes that it is enforceable under law. The word used is not anywhere.
If it is not,
I think that's a debatable case. It's not an easy thing. Because the word used is an arbitration agreement may be in the form of an arbitration clause in a contract or in the form of a separate agreement.
Please read that section 11.6a.
11.6a. Where under an appointment procedure agreed upon by the parties, a party fails to act as required under that procedure, or the parties or the 2 appointed arbitrators fail to reach an agreement expected of them under this procedure, or a person including an institution fails to perform any function entrusted to him or under that procedure. The appointment shall be made on an application of the party by the arbitral institution designated by the Supreme Court in the case of international commercial arbitration, or by the High Court in the case of arbitrations other than international commercial arbitration, as the case may be, to take the necessary measure, unless the agreement on the appointment procedure provides other means for securing the appointment.
See the last words, agreement.
To take necessary measure unless the agreement on the appointment procedure provides other means for securing the appointment.
Yes. That's regarding appointment of arbitration.
That is section 11 appointment. I think 7.2 will have the answer in itself, because we from class 1 onwards start learn what is a contract. Contract is all those agreements which are enforceable under law alone are contracts. So
Yes.
Right. If the document itself is in question, then where is
I don't know.
the arbitration clause? That is the question I asked earlier. So we come back to that itself, sir.
Okay, Prem. Now I think
The question has come up.
yes.
2021 KLP says that impounding is not possible in case of unstamped documents. I think that's
sir has put a question. Correct. Yeah.
Harila, I think. Hello, 2021 KLP.
635 says impounding is not possible in a case of unstamped documents and only applicable to insufficiently stamped documents. Can you clarify this?
I don't think so. We'll have to see the judgment.
Because if there is 0 stamp, there is no question of insufficiency, because there is no stamp at all. So can you validate something in plain paper by saying that 10 times, and I think after the amendment 20 times to be paid?
Insufficiently, the
Can the term insufficiently mean nil as well? Nil stamp, no stamp at all.
nil stamp. So,
But then the presiding officer wouldn't know what is the stamp duty. At least in another document, there is an amount specified, so the deficiency will be filled up. If there is nothing, then where does he start with? Then it has to go back to the collector only.
it is the word used in section 33 is not duly stamped. Now, it doesn't say insufficiently or unstamped.
No, you cannot go by the literal interpretation here, because if you go by the literal interpretation, then of course that is going to ultimately lead to an absurdity. Now here you have to go by the purposive interpretation. not duly stamped. See the last portion.
Hmm. Duly stamped and insufficient would stand on the same footing, because if it has not been done, you'll have to start the process from wherever it is and start from there. They would be on the same
Duly
footing.
stamped means it might take in not at all stamped even. I don't know. Let us
Yeah,
say
it's-
2021 KLT 635.
If it has been required to be duly stamped, then that would be the amount that has to be
There is
taken.
one. I think it is by Justice Harilal and Justice Annie Joseph.
Yes. Do you have the soft copy there?
Animate.
2021 KLT 635. 2020 volume 1 KLT 635. volume 1 KLT 635. Binded.
1 KLT Aranu.
My thing is, impounding is only for the purpose of validating it by payment of insufficient
duty.
court stamp duty and
The penalty.
penalty.
Ah.
Suppose it is not stamped, what is the purpose of impounding it? It is totally inadmissible. See, the task of impounding is that might be what is contained in the decision.
The
We will ask
impounding is
Arshad
to-
sir. I think
to-
Arshad sir is unmuted. Arshad sir, just which is this decision 2021 KLT 635 which you are alluding to?
It says that if it is not stamped, then you cannot validate it. But I am doubtful whether it is the correct intention, because if suppose if a document is to be stamped with 100 rupees, and if there is no stamp at all, even if you can say you can pay 10 times and validate it. But the decision says decision distinguishes unstamped and insufficiently stamped. I think every unstamped document which needs to be stamped is also not duly stamped.
No, which is the judge?
I think Justice Somarajan.
Okay. But
It is Thomas
Yes,
George versus
yes,
George
yes,
Woody.
yes,
Thomas
yes,
George versus George Woody.
Okay. I got
Yes.
it. Correct.
I just read the heading. In the case of an insufficiently stamped document or defectively stamped document, the provisions for impounding the document, section 33, 34, and 35 of the State Act, namely Kerala Stamp Act 1959, corresponding to section 33, 35, 36 of the Central Act. The
Yes,
Indian
because
Stamp Act
see,
1899 would be
I remember
applicable.
the ruling, because here he was on that literal interpretation.
Yes.
He took into consideration 3 sections, 33, 34, and 35 of the Kerala Stamp Act.
Correct.
And it is insufficient.
Pari material with 33, 35, and 36 of the Central Act.
Exactly. So he took on the words unstamped. That word unstamped was absent. So the legislature has deliberately, has inserted the word not duly stamped. So he tries out to find the intention. Of course, if you go by the literal interpretation, what he says is correct.
He relies on 2009 Supreme Court 1489 and 2001 Supreme Court 358. Let us see.
2009?
2009 Supreme Court 1489 AR.
Okay. Then
That is
1489?
Avinash Kumar Chauhan
Avinash Kumar
versus
Chauhan,
Mukesh
yes.
Kumar Mishra has laid down the legal position that a document not duly stamped unless impounded under section 30 of the Stamp Act shall be inadmissible. That is we are referred to.
That is by virtue of 35.
Yes, the other one is Malaysian Airlines System, etc. Very as settled by the Apex Court, etc. After the expiry of 3 months period, it can be impounded, and the legal position as that was
That is 2001 decision you are referring to.
Yes.
Right. Because here the thing is that I think Justice Somarajan went on to consider these 3 sections
He
together.
went on to say, but in the case of an unstamped document, there cannot be any application of the above said provision, and as such, an unstamped document which was admitted in evidence without any objection or rejecting the objection is of no use except for collateral purpose and would stand outside the purview of section 35 of the Kerala Stamp Act corresponding to section 36 of the Central Act.
But I think that was going by that literal interpretation. whether
Same.
not stamped can mean unstamped. As to normally, because a purposive interpretation has to be given.
Same, suppose an unstamped document which ought to have been stamped is produced. What is the purpose of impounding it? It cannot be validated. Cannot be validated.
And whereas he relies on AR 1956 Madras 454, Subramanya Chettiar versus Revenue Divisional Officer, wherein it was held that an unstamped or deficiently stamped document is not void and it is effective from the date of its execution, though it is incapable of being made use of as evidence until it is stamped properly.
Yes.
But see, that particular judgment of 56 Madras, that never, you can see absolutely nothing like an unstamped document or an insufficiently stamped document in that decision.
He refers to section 2E. Duly stamped as applied to an instrument means that the instrument bears adhesive or impressed stamp of not less than the proper amount.
Yes.
And that stamp has been affixed or used in accordance with the law.
2E, no?
2E. Duly stamped and 211 of Indian Stamp Act.
Correct. 2E, of course, correct. Because 2E Kerala Stamp Act, right? 2E. 2E is duly stamped, correct.
Less means, not less means it can also be zero, no?
Yeah, it can be zero. Just see the duly stamped is applied to an instrument means that the instrument bears an adhesive or impressed stamp of not less than the proper amount. And that such stamp has been affixed or used in accordance with the law for the time being in force in India.
Correct.
Insufficiently is.
So if not duly stamped, it can be absence of stamp as well.
Correct. What is it? See, if it is interpreted that way, absolutely correct. Because if it is not duly stamped means, that means there should be some stamp, cannot be zero.
Yes.
Cannot be zero.
Cannot be zero.
Absolutely true. Absolutely true.
Because an unstamped document is not at all admissible in evidence. It cannot be cured at all.
Yes.
But a deficiently stamped document can be validated by impounding, after impounding, and asking to pay the penalty. And
section 2E, whether the section 2E of this Kerala stamp.
And Prem, section 33 subclause 2 is also relied. For that purpose, every such person shall examine every instrument so chargeable and so produced or coming before him in order to ascertain whether it is stamped with a stamp of the value and description required. So there is some sort of stamp there, whether it's of the description.
True.
Yes.
Correct.
What
Justice Ramarajan held, of course, even though it's little interpretation, if you go back, see whether section 2E of the Kerala Stamp Act, whether you have what is the corresponding provision in the Indian Stamp Act?
211.
What does that say?
211, just I showed it on the screen. 1 second.
Such stamp has been
Duly stamped.
This one. I'll read from the Kerala. Kerala says duly stamped as applied to an instrument means that the instrument bears an adhesive impressed or e-stamp of not less than the proper amount and that such stamp has been affixed or used in accordance with the law for the time being in force in the territories of state of Kerala.
Same thing.
Same. So that means, of course, what his lordship is correct.
Yes.
Because see, when it is there in 2E means, duly stamp means, of course, it cannot be zero.
And there is another point, this thing also. An insufficiently stamped document is prohibited, is made inadmissible in evidence by imposition of law, this act.
Absolutely. Because
document not at all stamped is per se inadmissible.
What was the document in this particular case?
Is per se inadmissible.
I think the cumulative view would be that zero stamp or no stamp at all may not be saved or cannot be saved by this provision.
Yes.
We usually come across only documents with zero stamp. We don't come across any document with less stamp. Usually white paper transactions.
White paper transactions.
No, here land lease are made in 100 rupees stamp paper.
Okay.
And say mention that they for 11 months.
you don't have to register it.
That of course, but they have to, it has to bear the stamp duty.
Stamp duty, true.
But again, you can say one thing. If you see the 211, which corresponds to the 2E, what is the kind of the definition? See
With
the
reference to this act.
Duly stamped as applied to instrument means that the instrument
as applied to an instrument means that the instrument bears.
Bears an adhesive.
Not
Please take me to the first. Section 2. How does it start with? Section 2 is it definition? Definition.
It's not
It is like
explanation.
unless it is repugnant. There is
Unless there is something repugnant
in the subject or context.
See, kindly see. Here again, you can have in this act, unless there is something which is repugnant in subject or context, that particular text, it has to take its color from the context also used.
Yes.
Legislature has applied its wisdom very, very clearly.
Correct.
The text has to take its color from the context.
Yes.
So that is saved by the definition clause as well. You can go both ways. Debatable issue, but anyway, settle means we have to.
Correct.
Because Justice Somarajan, I think that 155, section 155 of the CRPC,
non-cognizable.
referred to a police officer. Of course, if you go by the literal meaning, absolutely true.
Unless,
go by the literal meaning.
Unless the context
is decision says otherwise. Because ultimately, judges themselves create much confusion. Supreme Court holds one thing at one point of time, subsequently they change it. High courts say something at one point of time, then they change it. There is no settled law. That is why, see, now even though we attained the freedom in 47, we adopted the laws during 1950. Now it is more than 70 years, 70 plus. No settled laws.
Man, why do you want settled laws? Because you are applying it on an unsettled society. So it cannot be settled or static. It has to be organic. It has to keep on growing, modulating.
Unless you have the laws settled in the right manner, you cannot have an orderly society.
Then the concept, the right, will have to be defined in each one's perception.
I would tell you why. Why? Because when Mr. Rao said at the beginning of this talk, see the Aryan Khan judgment. See, before the mighty, the law could bend down. The same set of standard may not be applicable to a person who stands on a different footing like a common man.
Prem, it is just like what George Orwell said. All are equal, some are more equal.
Or show me the face, I'll show you the law.
Yes. Virupaksha sir, anything more to be added on the subject? Your final passing shot?
We will have to examine this issue, last taken issue, whether it's totally unstamped.
No. We are not here for answers, sir. Definitely. We leave open or we leave behind more questions than what are answered, so that this August Assembly will dwell on it and we will be part of this, what you call expansion or development of law or legal field. So, I mean, that exactly is the intention. And thank you, Ashad sir, for bringing this proposition here so that we could discuss and deliberate on that. And I'm sure that this August Assembly, this enlightened crowd would go deep into it and come up with more thoughts, more different angles, views on the same thing.
That is the actual premise of letils, which I am very grateful to, because time not being the constraint and the open mind being the second option. This is a beautiful platform where we can discuss everything threadbare. And we need to thank you all for getting, at least I need to thank all of you all for bringing this platform, which no other webinar anywhere in India is doing. Let me be very honest with you.
Thank you, sir. Thank you. And
it's a very beautiful concept. And that's why I said it. I don't want to miss this at any cost. Any other webinar, I may give it a go by, but these 2 days are perpetually fixed on my calendar.
And for that matter, sir, tomorrow it is not in the morning, it's in the evening at the request of the speaker. Tomorrow in the 261st session, we have the senior advocate of High Court of Andhra Pradesh and Telangana, Sri P. Sri Raghuram sir. He'll be on the subject need of administrative practices for constitution balance with reference to Indian scenario. And to conclude today's session, may I request Prem to conclude the session with your remarks.
No, I have nothing more to add. And to conclude, I would just say, because as Arshad has pointed out that 2021 KB 635, just see, Kerala High Court has so far seen only 2 judges who go by what is there in the statute.
Yes.
One is Justice Hema and the other is Justice Somaraj. They are not bothered about what are the decisions or the ratios which are laid down by the apex court. They don't go by the judgments. They go by the statute. Actually, that is the best method. Go by the statute. Judgments, of course, you may have judgments this way, that way. Totally confusing. But that is the legislative intent. That is what has to be applied.
Prem sir, sorry to butt in, but that's exactly what the Supreme Court said in Octo Circuit.
Correct.
Saying that if the statute says, even the High Court can't go beyond the statute.
Because courts can only explain or expound the laws.
Laws, exactly.
Pieces. But they
And
cannot.
that too in the particular circumstance of the case. They are dealing. That too with reference to the particular facts and circumstances.
Particular facts and circumstances, because each case has to rest on its own facts. Because, see, it will change of facts, of course. Ambika Quarry, we have a lot of, like Bhavnagar University, we have a lot of rulings, multitudes of judgments come one after the other. One change of fact can make a whole difference.
Yes, yes.
And you cannot fit into that particular precedent. Because nowadays, what the courts are doing is, they are just culling out certain sentences from some judgments. Stray sentences are being culled out.
Copy paste.
And given direction.
Copy paste.
Because Justice Somarajan, of course, he's a wonderful judge. He goes by the correct interpretation. Because he takes down the statute, goes by the statute. He's not bothered about what are the judgments. Actually, that's a correct, because there were only 2 judges. One is Justice Somarajan and the other is Justice Hema. Absolutely no presidential bias. This is what has to come.
So let us conclude the session 260th, and with a special thanks to Virupaksha Gowda sir for making this discussion so live and interactive, and all of you who participated in your own way by the constructive inputs and thoughts. Let us hope by this proactive way of approach to the different nuances of law, we will improve ourselves, and in turn, the system also may improve. And that's what Littles is all about, like K. Rao sir said. So till we meet again tomorrow at 5:30, please do take care and stay safe. Thank you once again, Virupaksha Gowda sir, and all of you participants for this wonderful Saturday evening. Thank you very much.